how to avoid the first-headed and the second-headed monster, the tax man. Oh my, Elder Law Care attorney Patrick Kelleher. Today's question at Elder Law Care is the following. If you're a single person, what are some serious considerations you need and ought to put into your trust, Senate, or estate plan? If you are a single person or you know and love a single person, because I'm going to give you 3 reasons or 3 strategies how you can slay some of these beasts right here being a single person. Folks, number 1, create a trust, because when you're a married person, you can simply carry your assets or hold your assets legally to Bill and Mary on the deed to the home, because that'll avoid probate court when Bill passes away. At least you're delaying or deferring probate. But guess what, single folks? You do not have that luxury because you don't have a Bill or a Mary in your life. You're single, and only you individually, personally, are on that bank account or on that deed if you own real estate. And if you get hit by the bus of life tomorrow, folks, where does your asset or assets end up? That is correct, probate court. Now your loved ones are going through the arduous, lengthy probate court proceeding, 1.5 years or longer, paying probate attorneys, meters running by the hour. You just introduce them to the messes and stresses of probate court, as well as the economic and emotional headaches of probate court. How do you think your loved ones are going to feel now cleaning up that mess, right? So folks, the solution is, look at our 3-step process chart. Now, if you get hit by the bus of life, game changer, no probate court, because sadly people die, but trusts do not. So your successor trustee that you picked, that you chose, not somebody on the court list, not a private attorney the judge picks, but you pick someone in advance that you put into your trust plan, legally steps into your shoes as your successor, alternate trustee. Game changer right there, folks. Number 1, make sure you create that trust. But more importantly, make sure you fund it, getting your treasures into the trust or treasure chest. That's number 1. Folks, number 2, most of us from an actuarial statistical standpoint will become disabled or incapacitated before we completely check out. So you want to make sure you have the Big 6 disability planning in place. The Big 6 disability planning, folks, is designed to avoid disability probate court. Probate court's a 2-headed monster. Death probate that we just talked about. And the first reason, create the trust that's funded. And the second, avoid disability probate. You need the Big 6 disability planning is the sword and shield that slays that disability probate beast. Conservatorships. You need a durable power of attorney. If you're 60 and over, make sure your elder law attorney creates it with enhanced elder law powers to avoid conservatorships at the probate court. Your people that you pick and chose are stepping into your shoes legally day number 1 if and when you became completely incapacitated. They're managing your affairs, managing your finances, paying your bills for your benefit without the necessity of someone petitioning the probate court for conservatorship. Or for medical decisions, they call it guardianship. So you need that comprehensive healthcare proxy. Folks, number 3, if you're a single person, really, really important to make sure that in your power of attorney that you include what I call gifting powers in there. So your attorney, in fact, and your power of attorney has the legal authority to make gifts, maybe in excess of the annual gift tax exclusion. That's a second-headed monster. If you live in a state like Massachusetts that still has a fairly low estate tax threshold, we're at $1 million for several years, and recently we went up to $2 million. But a lot of our clients who are still kind of middle class have a lot of assets that they've accumulated in their lifetimes, and they're over $2 million. What does that mean? The Massachusetts Department of Revenue, the estate tax, will tax their estate when they're gone away. Really important, if you don't want to share your inheritance with the taxing authority and you're a single person, you cannot do tax planning like a married couple can do. So single people, have your attorney put it in your trust, in your durable power of attorney, gifting powers to your trustee in the trust, and attorney in fact in your power of attorney to allow them to make gifts in excess of the annual gift tax exclusion. In the event you're in the late 4th quarter of life and you're over $2 million, you're not going into a nursing home, and you're going home like my late mom, your agent, your attorney in fact, your trustee will have legal authority to make gifts out of your estate before you go up to your cloud, and that may very well reduce your taxable estate for the estate tax. It's an important power to have in your trust, in your elder law toolbox. Folks, there you have it. 3 strategies for single folks to protect themselves in estate planning and elder law. Don't just take notes, don't just listen. Now go take action and put it to use for yourself and your loved ones. Folks, thanks for joining us here. Make sure you subscribe at elderlawcare.com. Click that button because we will keep you updated with other important elder law matters. Thanks for joining us here today.